warrantless searches for blood. A few years ago, back in 2013, the Supreme Court, U.S. Supreme Court, decided State v. McNeely, a DWI case, and the issue before the court had to do with warrantless searches and whether the fact that alcohol dissipates in the body was an exigent circumstance permitting a blood draw to occur without a warrant. And the Supreme Court said no. It also recognized, however, that there could be other circumstances that would warrant an exigent situation, such as the length of time it takes to obtain a search warrant, and therefore possible loss of evidence, which is a more traditional look at exigent circumstances. Somewhat separately from that, we have a statute, North Carolina 20-16.2, which allows, under the implied consent laws, for officers to obtain blood of an unconscious person without a warrant. So, the case we have of State v. Romanoff, I'm thinking Avengers, looked at the constitutionality of our implied consent warrantless blood draw law. Now, in Romano, a defendant who was extremely impaired was arrested for DWI and taken to the hospital. Staff there determined he needed to be medicated due to his level of agitation. When I say extremely impaired, officer responded to a dispatch indicating a white male wearing a sweater backwards and carrying a liquor bottle had stopped his SUV in the middle of the road, gotten out, and stumbled across the highway. They found him nearby, incoherent, smelling of alcohol and vomit. So that's what they mean by extremely impaired. When the hospital staff decided he needed to be medicated, the officer was concerned that any medication administered could interfere, or rather cover, any evidence from a subsequent blood draw indicating that the defendant was impaired. So, he had the medical staff draw blood. They were already drawing blood for medical purposes, but he had them draw an additional sample in order to provide police with a blood sample prior to his being medicated. Basically, state Supreme Court held, considering McNeely as well as another case from North Dakota, warrantless blood draws of an unconscious person are unconstitutional. Officers must show exigent circumstances without a warrant or voluntary consent, but cannot simply rely on the statutory authority. In the case of State v. Lowe, the officers arrived to execute a search warrant at a residence, and when they arrived, they noticed a rental car parked in the driveway. Now, the search warrant authorized the search of the premises, vehicle, person, and other place or items described for the property and person in question. And the property and person in question was a Terrence Michael Turner, aka Michael Cooper Turner. That's what it says in the search warrant. Now, I'm sure some of you have already said, Turner and Lowe are not the same name. You are quite correct. The defendant, David Matthew Lowe, was an overnight guest of Mr. Turner's. When the officers executed the search warrant, they found 852 grams of marijuana and 14 grams of crushed MDMA in the bedroom where Mr. Lowe and his girlfriend had been sleeping. When they searched the rental car, they found other items belonging to the defendant, as well as a few hundred doses of MDMA, LSD, and $6,000 in currency. The issue being, where the search warrant is addressed to the property and person of Terrence Turner, aka Michael Turner, does that extend to the property of Mr. Lowe, most particularly the rental car? Now, if the search warrant describes the premises to be searched, a car may be searched even though the warrant contains no description. But that's traditionally been held to apply to vehicle owned by the property owner. Here, the rental vehicle was parked in the curtilage. And the type of items being looked for once they found them in the residence were of a nature and type that could also be located within the vehicle. And for that reason, our courts held that search of the rental vehicle was authorized by the search warrant issued in this case. Alright, here's one for Stokes Barnes, the horizontal gaze nystagmus. The HGN, one of the three-part standardized field sobriety test used in cases of suspected impaired driving. There have been several cases in the last few years calling into question who could testify as to the results of the HGN and what a witness would need to be able to testify to regarding the science behind the test. Essentially, what level of knowledge does the witness have to explain and validate that the HGN is a validated and appropriate, reliable test? Now, in 2017, cases from both the Court of Appeals and the State Supreme Court clarified what was necessary. As a general rule for expert evidence, the rules of evidence set the legal standards. And these are based on the constitutional requirements that for evidence to be admissible, the testifying witness must be qualified and accepted by the court as an expert. And an expert really means only that they have greater knowledge than a lay person, and that their level of knowledge can assist the trier of fact. Now, to qualify somebody as an expert, of course, you have to establish sufficient education and or experience in the field. The pertinent rule A1, that for the HGN, a witness qualified and with proper foundation may give testimony solely on the issue of impairment and not on the issue of specific alcohol concentration level related to the HGN. Well, I hope that clarified things for you. And remember, you don't need to testify regarding the underlying science, but you should still have a familiarity with that information. And depending on the DA and how obstreperous your defender is, they might look to have you provide some testimony on the topic. Again, that's what I talked to Del Morrill about. Get his take on the individual case. And now let's talk about sex offenders and social media and our folks getting their clocks cleaned. And when I say our folks, I'm not saying the county sheriff's office. But rather the state of North Carolina. General Statute 14-202.5 had prohibited registered sex offenders from accessing social media websites generally. Nothing limited to potential victims, including any sites that allow the user to share photos, messages, or post on message boards. This was challenged some years ago in a prosecution on the grounds that it was an infringement on the individual's First Amendment freedom of speech guarantees. Such limitations are only permissible when they are necessary to further a legitimate government interest. And the Supreme Court held that the North Carolina General Statute in Miranda. Now, the Fifth Amendment right against self-incrimination is based on the custodial interrogation, and it is tied to being in custody, which is arrest or conditions tantamount thereto. And because it's based on custody, it is not charge specific. That's a Sixth Amendment issue, but merely on that status. And of course, any incriminating statements elicited in violation of the Fifth Amendment may be excluded, the exclusionary rule. Now, the Miranda rights, as you recall them, and the waiver. The waiver of the Miranda rights must first be knowing, properly informed and understood by the suspect. It must be voluntary, which means not the product of force or coercion. It is waiverable at the choice of the suspect. Their attorney does not have to be present, and the attorney cannot assert the Fifth Amendment right for the client if the suspect does not wish to do so. If the decision is not clear, you can certainly ask clarifying questions, but it is not the obligation of law enforcement, generally, to ask whether or not somebody wants to invoke their rights. And of course, if a suspect asserts his rights, whether it's the right to silence or the right to counsel, all questioning must immediately stop. Now, when we talk about custody, as I just said, arrest or the functional equivalent. And the standard is, from an objective standpoint, would a reasonable person in the suspect's position believe they were under arrest? And that will be evaluated under the totality of the circumstances. All right, so let's look at the case of U.S. v. Giddens. Now, in Giddens, the defendant was suspected by law enforcement of being involved in a bank robbery and believed he had allowed his car to be used in other bank robberies. Now, 2 other suspects had been arrested and they had impounded the defendant's car. The defendant was called down ostensibly to retrieve his car and taken into an interview room. That room had 2 doors, one behind the questioning officer, the other one basically next to the defendant. Now, after getting the defendant's license info, one agency member left through the door next to the defendant, audibly locking the door in the process, which caused the defendant to look toward it. At this point, the defendant asked, "Am I in trouble?" To the response to which he was told, "No, you're here getting your car, right?" The initial questioning officer then left the room, checking that the door behind him locked before he left. Another officer comes in, produces a waiver form, and gives it to the defendant, who read the form. You now have this exchange. So the defendant, what I'm asking, is this the procedure for me to get my car back? Detective, yeah. In order for us to ask you questions, because the vehicle was used in a crime, by law, we have to go over these rights. If we start asking you stuff and you don't want to talk to us, then don't talk to us. But we're just trying to figure out some issues. Defendant, but do I still get my car? Detective, before I release the car to you, I would like to know some answers. I would like to know some answers before we release the car back to you. Defendant, I'm not in trouble or anything, am I? Detective, not at this point, no. We'll find out what's going on. So, defendant signs the Miranda waiver, subsequently invokes his Fifth Amendment right to counsel, and is arrested. But before he invoked his rights, the defendant had made certain statements, both made before and after he signed the Miranda waiver. On appeal, the defendant argued that his statements were involuntary and that the Miranda waiver was not valid. So what do you think? First and foremost, was the defendant in custody? The Fourth Circuit concluded a reasonable person would not feel free to leave without giving up the opportunity to reclaim his car. Now, you've got a couple of issues here. One, the locked doors. Oh, by the way, you'll see here at least twice during questioning the detective took defendant's phone away. But more importantly, you had locked doors. They were known to be locked by the defendant. In fact, it seems law enforcement wanted to make damn sure he knew they were locked. And the police had his car, and indicated they were not returning the car until he answered their questions. The second issue was whether or not defendant's waiver, as once you've established yes, he had to be given his rights, was it voluntary, the result of coercion? And the court looked at two things. One, the way they conditioned return of his vehicle on signing the Miranda waiver and recognizing that he needed that car for transportation to and from work and hence to earn a living. And second, that they lied to him when he asked if he was in trouble. Now, typically, some falsehood and misdirection is not problematic. It is allowed. But untruths cannot be used to the point that those lies overcome the will of the defendant. I think the bigger problem is this was an individual who, when he was trying to find out if he was in trouble, law enforcement kept emphasizing, if you want your car back, you need to talk to us, you need to answer these questions. And based on that, the Fourth Circuit concluded his statements were the product of coercion, involuntary, and therefore inadmissible at trial. I think the main things you have to take away from this case are that first, don't use the return of property as a justification to compel somebody to answer questions. That was plainly coercive. And at another level, the Fourth Circuit has moved into the realm of saying that if somebody asks if they're a suspect, you cannot lie to them and say no. Not when it gets to the point that that will overcome the will of the defendant. And when it was tied in to the effort to return his property or to recover his property, that became coercive as well.